Hi, and welcome to Ward 13. I'm John Hopwood, and tonight we are going to be discussing the impeachment of Justice David Brock. We have the two authors of the book, John Cerullo. Am I pronouncing your name right?
Yes, that's right.
You know, where I come from, unless you come from below the Mason-Dixon line, you can't pronounce Hopwood. I don't know why that is, but it just is. And David Steelman. Now, Mr. John, you are a professor of European history at UNH Manchester, and David, you were what was the organization? I'm blanking out now.
National Center for State Courts.
Right.
Yes.
And since I've lost my notes, because this is the only time, folks, I've ever been nervous. Even when I was being sued by Ted Gatzis, those shows afterwards, I wasn't nervous. But why don't we're going to do it. There was the old thing, journalism, when I was a kid in the 70s. Who, what, and why. We already know the where. It's New Hampshire. And for the who, tell us about why don't you introduce yourselves, and then we'll introduce our other panelists, and then we'll get on to why you wrote this book. So, John, this is your first time on television.
It is.
Yep.
Well, as you noted, I was a professor. I'm semi-retired right now of European history. And in my researches, I got very interested in legal history and legal theory.
Right.
And I got very interested on the basis of some European incidents, especially French incidents, in this sort of question of conflicts between the realm of the political and the realm of the legal. Where
Right.
does politics end and law begin? Where should law end and politics begin? And the interface between them. And that was what drew my interest to the impeachment of the Chief Justice of this state. It was a little outside my bailiwick, but I was very fortunate to have a co-author who knew a great deal about this state court and, in fact, about every state court. And I wanted to sort of dig into this question of impeachment itself as a process which is part political and part, I would say, juridical.
Yeah.
I wanted to dig into the question of sort of legislative-judicial relations, legislature representing, of course, the political imperative, the judicial branch representing sort of what one hopes is a very stable commitment, solid commitment to rule of law. So that's how I came to be involved in this.
And David?
I'm a resident of Manchester, New Hampshire. I'm admitted to practice in New Hampshire and Massachusetts, retired from the bar. I began working in 1974 with a nonprofit organization called the National Center for State Courts. Worked for them for 40 years as a staff attorney, a vice president, and then a management consultant, which gave me the opportunity to work with court leaders in all of the states and to visit most of them, and also to work with courts in other countries. And when John and I started to talk about this, I found it very, very interesting, having worked with Chief Justice Brock and his predecessors and his colleagues in the administration of the court system, having made some contribution to changes in New Hampshire, the creation of the public defender system and the unification of the court system. And so this is a particularly interesting inquiry for me to be working with my friend John.
And I'll introduce our guests. We have Joseph D. Steinfeld, who is a distinguished lawyer. And in 2000, the New Hampshire State Legislature asked you to investigate charges against 3 justices, and then you were brought on as the special prosecutor.
Yes, that's correct. I grew up in New Hampshire, but back at the time I was at a Boston law firm called Hill and Barlow. No longer exists, but I still practice in Boston at a firm called Prince Lobel and in Keene, New Hampshire, where I now live. And as you say, John, I was called and came up and met with some of the legislators on both sides of the aisle, and there was a lot of talk at the time about the problems the court was having, mostly centering around Justice Thayer and then Chief Justice Brock. and the Speaker of the House asked me to conduct the investigation, and that's what I did.
Okay, and interestingly, one of the books you've written multiple books, is about your Claremont, you grew up in Claremont.
Yes, I did. I was born and raised there, went to school there.
Yeah.
And all my life, if people ask me, where are you from, I always say Claremont, no matter where I live.
Claremont boy, my New Hampshire roots, and gift of memory. Which brings us to Attorney John Tobin, which I would think that you were mostly known for the Claremont cases.
I was one of the lawyers in the Claremont case.
Yes.
The part of it that I worked on was the property tax side, but I was involved from the early days of the case. And I think I'm here tonight to talk about how the Claremont case may have impacted the impeachment of the Chief Justice. And based on my involvement in the case and also just my observations of the court system and the legislature in the last 25 years.
Okay, now I found your book because I was researching the 25th Amendment. And we're not going to talk about the impeachment of a president. When in 1976, when I first was involved in the New Hampshire primary as a 16-year-old, I chose Birch Bayh, who I guess he was the only person since the founding fathers to write 2 constitutional amendments, because one of them that would have direct election of the president overwhelmingly passed the House, but was bottled up by the Southern Democratic legislatures. It never got a committee, and of course the ERA failed. But I love this stuff. There's so much to do, but what is impeachment? What is impeachment? As I told you, I have books in my house about the impeachment of Hastings back in not Alcee Hastings, who was involved. I was down at the National Whistleblower Center, so only tangentially had anything to do with that, who was a federal judge, now a U.S. congressman, who was impeached as a federal judge. But Alcee Hastings was back in the old Parliament. Took 5 years at the end of the 18th century to impeach him. So impeachment was part of the process that came with the English colonies. But what is impeachment?
Impeachment does go back to British practice. I think the first impeachment was somewhere in the 14th century. It was one of the few methods at the English Parliament's disposal to remove what they considered to be a corrupt or incompetent royal administrator.
Right.
The last British impeachment, I think, was 1806, and it will not happen again in England. It migrated to colonial legislatures, and in the United States, colonial legislatures exercised the power of impeachment in the pre-revolutionary era pretty aggressively.
They did.
They did.
One of the reasons I read was the Parliament went so after royal favorites.
Yes.
And in the old days, I guess it would end up with an execution.
It
but
could.
They went after them. That when the founding fathers had the impeachment of the president put in the Constitution, they moved the power from the House
Yes.
to the Senate.
Well, the power
So-
to try.
The power to try, right. But the power to impeach, that's a process in itself.
Yes.
And as Mr. Steinfeld, you wrote a piece for the Concord Monitor, and I think it was just recently, about the process of impeachment and whether the process of impeachment is a process that has an integrity all of its own, as an investigative device, that when you were undergoing that, the idea of whether it would end in a conviction was not paramount.
Well, that's right, John. It can be compared, I suppose, to a grand jury which investigates and then may indict someone but does not try the person.
Okay.
That goes to a separate branch of government, so that throughout this country, as in England, it goes on one side to accuse and on the other side actually to adjudicate the case.
Right, because in England, until they got their Supreme Court, it was the law lords. But under the English system, it was that Parliament was still the adjudicator of the law. But that changed in the United States, did it not? But that's what was strange about New Hampshire, because did not New Hampshire have a tradition of that later than any other state, perhaps? What happened in 1964 in New Hampshire?
It was a constitutional convention, And as a result of that constitutional convention and its recommendations to the electorate, in 1966, the electorate passed a constitutional amendment that for the first time wrote the New Hampshire Supreme and Superior Courts into the Constitution.
So they weren't in part of the Constitution?
They were not mentioned or they were not sort of instantiated in the Constitution.
That's
until
okay.
then.
I have people call me and harass me at times.
And
We're
what
not
that meant-
taking calls tonight, but
What that meant was that the entire judicial branch of New Hampshire state government was very much a creature of the legislature. Legislature could set and create courts, and it could dissolve courts. It set jurisdictions. It had a great many other powers, which we might get into eventually. In 1966, that began to change when the courts, at least those high courts, were given their own sort of independent constitutional status.
now one thing that fascinated me, and we will be getting to you, don't worry, when we get towards
That's
Claremont, is the Claremont decisions, was that I was surprised because I was stationed in the South and my father used to live in Atlanta, so there were elected judges
Not in
in
this state.
Texas,
Yeah.
but not in this state. But I understand that that is common in other states to have elected judges.
The great majority of states have elected judges by some means, whether it's partisan or nonpartisan. Almost always, if there's a vacancy on the court, judge retires or dies, and it's the governor who appoints a judge, and then that judge is required to run for retention in the next general election. The New England states, by and large, are about the only states in the country where this is not the case. In the New England states, if I'm correct, every judge is appointed. Now, there are some variations on that. They're appointed by the legislature in some states, in others by the governor. And in New Hampshire, the governor the governor nominates with the approval of the executive council, which is unusual to have an executive council of such influence in the process.
Are we the last state? Massachusetts once had an executive
Massachusetts
council.
has an executive council, but
Still
it
does.
has nowhere near the power and authority that's exercised by the executive council in New Hampshire.
They have a strong governor system.
They have a strong governor, correct.
See, the closest thing I remember, and I wasn't in California, I lived in California for a long time, was the recall of Rose
Yes.
Bird, which,
Yes.
but that was that old, when you're out in the West, they have the populism. My God, every 4 years we're voting on the death, all these propositions, there would be dozens of them. Every year, 4 years, there's another thing about expanding the death penalty and stuff like that. But, so what happened, and I think with the courts, there's a tension between, we're a democracy. We don't want to go down this road because we could have 4 hours. Earl Warren, as I said, I remember as a kid, impeach Earl Warren. And there was the judicial activism, I would say, from the left rather than the right. Because when I read, I used to be a legal editor at Oxford University Press, and some of the legislators, the Supreme Courts in the past, certainly, in my mind or opinion, would have been acting as super legislators, but they weren't goring the oxes like the Warren court did. Now, did David Brock? Let's talk. What does David Brock? What was he indicted for? Well, what was the bill of impeachment? You were the investigator, Mr. Steinfeld, and then you were called on to be the special prosecutor. What were the charges?
Well, one of the charges had to do with Justice Thayer's divorce.
This was a member of the Supreme Court who was divorced.
That is
Yeah.
right. And his wife appealed the divorce ruling to the Supreme Court. All of the members of the Supreme Court were disqualified. They had to
Right.
recuse themselves because it was a fellow member of the court. In connection with that matter, Chief Justice Brock was appointing essentially a pickup team of 5 lower court judges to constitute the Supreme Court for the appeal.
For that
And
appeal.
there was a serious question that arose when Chief Justice Brock discussed his chosen nominee with the other members of the court. It came, I won't go into too much detail, but the clerk of court became very concerned and wrote a memorandum And that essentially created one of the grounds of impeachment. And
Was it about influencing the justices?
It had to do with whether that constituted an impeachable offense.
Okay.
And the New Hampshire Constitution is quite vague about what offenses are impeachable, but there were three others. A second one had to do with the fact that allegedly the Chief Justice made a phone call to a Superior Court judge, Judge Gray, about a case that Judge Gray was hearing during the course of the case. And a state senator was a participant in that case. And so the question was whether that telephone call was an impeachable offense. A third concern had to do with the practice of the court, which predated Chief Justice Brock, whereby the judges who were out of the case, recused from
Right.
the case, would nonetheless sit not in the courtroom, but in the chambers afterwards all together and participate, at least in some limited way, in the discussion. And whether or not that constituted, in the words of the Constitution, either malpractice or maladministration of the court.
Right, those are the words. It's not the high crimes and misdemeanors of the
Correct.
U.S.
And
Constitution.
it's not corruption,
Right.
it's not bribery,
It's maladministration and
malpractice.
malpractice.
Those words are not exactly self-defining, you know. And the fourth of the four charges had to do with whether Chief Justice Brock perjured himself during the course of these proceedings. And so there were four questions that ultimately were tried to the Senate.
So it's interesting, and then this is just an aside of myself, but it's when you're creating a new system like in 1966, and these were the mores of the court, when you're investigating this and the House, you're actually, it's just not just the process of impeachment, but it's the process of how the court is working, the workings of the court.
Well, I represented the House Judiciary Committee.
House Judiciary Committee.
And the full House of Representatives directed the Judiciary Committee to conduct an investigation, which is what we did.
Yeah.
And we gathered evidence, we talked with people, we took depositions, we looked at a lot of documents, and we ultimately had several days of public hearings, which were televised. And then in the summer of 2000, the full House convened and they voted.
Was it 72% the vote, or am I just, we're going to bring in John Tobin, because when I'm just hearing that, I'm saying there was some, in the process of impeachment, and when you're doing the grand jury, you're looking into the workings of the court. I would think as a court, I never went to law school because, I was Biff from Death of a Salesman. I'm defying Willie, who wanted me to go, my father, who wanted me to go. But I was always fascinated by it. And remember, later, I remember the impeach Earl Warren. But of course, then there was when LBJ tried to replace Earl Warren, and then there was William O. Douglas. For some reason, I know the name, who LBJ appointed to be the Chief Justice, one of the greatest lawyers, and he came out of Yale Law School, but it's just defying me now.
Abe Fortas.
Abe Fortas, how could I not forget?
Didn't work out.
No, it didn't work out, and then I remember William O. Douglas and the problems with him, influence. And of course, then there were the expose of the 70s about the Warren Court and Edward Bennett Williams lobbying Warren, whether those are true or not. But now we're going to go to John Tobin. Why don't we introduce yourself and your take on what led up to the impeachment?
Well, I am far from the expert on the impeachment that these other three folks are. So my perspective is more of a lawyer practicing at that time, a lawyer who was involved in the Claremont case, and also someone who was present at the legislature for other reasons during a lot of this activity.
Could you briefly explain the Claremont case? Because
Well, the Claremont case is a case about how public education is funded in the state, and the issue is the issue at that time was whether education is a state responsibility, and the court resoundingly said that it is. And then the other question is if it is a state responsibility, how is it to be paid for? And the court said whatever tax the state picks, the rate has to be the same across the state. And then and now, in fact, the rates vary enormously.
And because we have property taxes are almost...
Property taxes are the way that we fund education in the state to a greater degree than any other state.
Yeah. Because I remember I was living in New York at the time, and New Jersey was going through this, but it seems like they just had the power to demand the equalization.
Well, lots of states have had school funding lawsuits, and that's because, as was mentioned a few minutes ago, the question of some of these are constitutional issues and they're legal issues, but they're also profoundly political issues.
Right.
It makes sense that the legislature would be debating and making decisions about how schools are structured and how they're paid for. At the same time, there are some constitutional principles, bedrock principles, that have to be followed. And so what you have continuously here and elsewhere is a back and forth about whether the legislature has created a system that meets with those constitutional precepts.
Right, in New Jersey, and as in other states I lived in, part of it was trying to get equity between the races because schools were so pitifully funded, for African Americans, people of color at that time, where in New Hampshire you didn't have that context. But the idea that some people at Claremont and the reaction against Claremont, because what was the decision of the Brock Court? Was he the Chief Justice?
He was
in
the Chief
Claremont?
Justice, and he took ownership of that decision, and his name was prominent in those decisions, and it was clear that it was his leadership that was taking those decisions. The first Claremont decision was unanimous. The second one that delved into the tax rate question was 4-1. From my perspective, that certainly caused concern in the legislature, but there were other things that happened that drove the impeachment at least as much or more. One of them was the problem that arose with Justice Thayer and the question of judges participating after they've been recused. There was also a scandal in the court system involving a judge named Fairbanks, who had essentially had abused juveniles and was not held to account for that for a long time. In some ways, it's analogous in a smaller way to the priest scandals of the Catholic Church. And so that scandal damaged the credibility of the court system
as an institution.
As an institution that could police itself.
Now, let's just say one thing. This is Manchester, New Hampshire, and we have a tax cap, and I think we have one of the lowest rates going to schools. My sister moved to Amherst because she had special needs kids. And there's always people say, well, I don't want to have to pay for kids. Even people close to me no longer have the kids say, well, I'm tired of paying all these taxes. But the Northwest Ordinance, which wasn't passed, which was with the first piece of legislation passed by Congress, was also passed under the Articles of Confederation, and it was about how states would come into the Union. And one part of that was that they would have to establish public schools. That was considered essential to, the American democracy. So there has been a mandate from the very beginning that we do have public schools. But we're talking about the political part of Claremont. What part, in your opinion, of you and David, did politics or a populist reaction against an elite court?
Yeah.
Because that's a big thing here in New Hampshire, live free or die.
It's a very big thing in New Hampshire. Do you want to?
Well, I think it's important for John to talk a little bit about the populism in general and the background of in New Hampshire that populist libertarian keeping our representatives close at hand. Go ahead, John, talk about that a little bit, please.
Well, let's see. The subtitle of our book is Civic Populism and Judicial Independence. And we felt, really, that what happened in the impeachment, the deep background of the impeachment, if you will, was a clash between an increasingly assertive, newly constitutionalized, newly independent, newly autonomous an increasingly assertive judicial branch. It had modernized, it had, quote, professionalized. We'll try to explain what we mean by that.
Which you were as a consultant to.
Yes,
That's
the courts.
exactly right.
You did all the workflows
We
and
worked
all
with
that.
them.
Yeah.
But that meant that the New Hampshire judiciary was really sort of out of kilter with the fundamental governing philosophy of the state,
Right.
as manifested in the organization of the other two branches. We describe that governing philosophy as populist. And what we meant by that was there was the civic culture of the state put a high priority on keeping elected representatives as closely tethered to the direct and immediate will of the people as possible.
Right.
It is hostile to the idea of professionalized legislators. It is hostile to the idea of a professionalized executive. We wanted citizen legislators. We wanted an executive that it was kept very sort of on a leash. That is why, for example, we have so many electoral districts in New Hampshire, so that the voting districts are relatively small. Each voter has a lot more power.
It's hard for me to explain because
Yeah.
I spent most of my adulthood, outside in New Hampshire.
Well-
I have 8 state legislatures, and now I have 4. And then when I was running for, I ran for the state house, and my ex, I lost my sister. Oh, now you're going to be fine because in California, where she lives, an assemblyman gets $92,000 and has 2 offices.
Well,
It's
that's
like,
not how we
Lisa,
do
it's
things.
not like that.
No.
It's just, what do you mean $100?
We have a very large legislature, a very large House of Representatives, comparatively small Senate.
4th biggest in the English-speaking world.
Third biggest, I believe, in the
Over
English-speaking world.
India and Congress, that's right.
We have short legislative sessions. We do not staff our legislators. We do not sort of gift them with large staffs, well-financed
House.
aides in the House, etc., because we don't want them professionalized. We do want them essentially doing what their voters tell them to do and nothing more. That is why our governor has only a 2-year term of office. He cannot make a great many appointments. He cannot exercise a great deal of control over the state budget unless he is authorized to do so by the Executive Council, which is, in a sense, kind of a wing of the legislature. Again, that's how we want it. That's how voters of this state want it. I don't know how many different constitutional amendments have been proposed over the state's history that aimed to, quote, professionalize or modernize the executive and legislative branches. Extend the governor's term of office to 4 years. Give the governor a line item veto. Drop the number of representatives in the House. If necessary, raise the number of senators.
Right.
Because their term of office is longer, they're a little less immediately and directly beholden to the electorate. All these measures failed.
Right.
The judiciary, on the other hand, from 1966 on, especially between 1966 and 1978, did modernize.
So it's an anomaly
It is an anomaly
to have
in
a
this state.
professional,
In this state. Well,
independent.
our original Constitution was very, very explicit. It instantiated legislative supremacy, as we've said. The judicial branch was very much, under the thumb of the legislature. The legislature could and did simply abolish entire courts, simply decompose them and recompose them with different
Jeffersonian.
personnel. In a
It's
sense,
very
yes.
much Jeffersonian.
In a sense, yes. And
Because
they would
Jeff-
argue it's a kind of populist brand of democracy in that the will of the people is unmediated, it is direct, it is powerful, it is not to be thwarted. The judiciary, the judicial branch, again, was an entirely different thing. And I think it's fair to say that our take on the impeachment was really, you can begin with the conflicts over the behavior of Justice Thayer, the court's recusal policy, what Brock himself did or didn't do, what information he did or didn't wrongly reveal, etc. You can go back before that and talk about legislative ire as a result of Claremont. You could go back before that and talk about legislative shock and dismay at the Fairbanks scandal, and especially at how hard it was to get information about the Fairbanks scandal, which some legislators felt the Judicial Conduct Committee, newly created to let the judiciary police itself, rather than accepting the monitoring of the legislature, had its confidentiality requirements and would not release a lot of that information, and some legislators felt that they were covering up even worse crimes.
Well, is that part of the profession? You and I are the only ones who aren't attorneys.
Yes.
Because you do want your lawyer to maintain confidentiality.
We could go into things like the advisory opinion. The New Hampshire Supreme Court is sometimes asked by the legislature to offer advisory opinions. We haven't yet passed this legislation. Before we do, we would like to hear your view on whether it would pass constitutional muster. That would not be a corporate or official finding of the court. It would simply be the opinion of the justices themselves prior to debate. They asked for an advisory opinion on whether they could alter standards of evidence in criminal cases involving people alleged to have committed sexual assault. Would evidence of prior sexual assaults be admissible? And the legislature had always had the power to sort of determine evidentiary standards. Now that the court is autonomous and is no longer sort of in the legislative embrace quite as tightly as it had been, the advisory opinion they got back was this is a matter of court protocol, court procedure. Questions of evidence are our concern, not yours. This created a lot of hostility among legislators. They could see the legislature, or they could see the judiciary slipping out of legislative control. That violated the populist standard, and we think that was the real deep background to the impeachment.
So that was part of the old system of 200 years before 1966?
Before 1966, legislators could do all these things.
But the court would offer such opinions? Because Abe Fortas was talking to LBJ while he was on the court, and I remember that was one of...
Well, his problem had to do also with the fact that he was on retainer from a private person. But on the subject of confidentiality, John, the attorney-client privilege is a kind of confidentiality, of course, but judicial confidentiality is a little different. And that question does come up here when it comes to transparency.
Right.
If you wanted 100% transparency, then the public could watch judges decide cases. But we don't do that. We have, within the confines of the deliberation room, total confidentiality. And that in turn raises an issue, which is when should the public interest in transparency trump the interests of judicial confidentiality? And you know, there are all kinds of privileges. The president has an executive privilege.
Right.
Question comes up, well, when is that overridden by more important, more compelling public interests? And we had that question very much in the course of the impeachment.
Now, what was you as the investigator, what was your findings? What did you recommend? Not you, but the committee recommend.
Important difference.
Right.
I intentionally did not recommend that they vote one way or the other. My job was to try and get all of the evidence, lay it out for them. I wrote 2 reports, and they would come to me and say, well, how do you think I should vote? And my answer was always the same. Nobody elected me. I don't get a vote. You need to decide this yourself. Now, we did consider something called the burden of proof, which is something lawyers always think about, trial lawyers. That's really all I am, is a trial lawyer.
Yes. You litigate.
I'm a trial lawyer. Yeah. And so, as you look at evidence, and they read the transcripts of the depositions, and they attended some of the depositions. We took a lot of depositions. They asked questions at the public hearing. This is before the impeachment vote in the full House. So we had these 22 legislators, and whatever may have been the precursor of this, the Claremont case, Fairbanks, who not only abused minors but stole a lot of money over in Newport, right next to Claremont, so I knew about that. But once you leave those, let's say, political concerns, and you get into an impeachment inquiry, then the members of the Judiciary Committee focused very much on their responsibility, each of them, to vote on the questions that were presented, and they voted to impeach on 3, not 4. The 4th impeachment article arose during the July 2000 debate in the full House. So that, there are several phases to this. All I know about is sort of the middle part. John Tobin knows a lot about what happened before.
Right.
And is very familiar with the aftermath. The 2 authors over here know everything about everything.
The big picture.
David knows the aftermath.
I'd just like a quick question, because we don't want to delve over that too much, but something like the Mueller report, people were expecting him to do this or that. When somebody, would you equate what your process is similar to that?
It's interesting you should ask. He and I were law partners, so I know him very well, and I have a very high regard for him. And I've read parts of the Mueller report. What I did was small potatoes by comparison. The stakes that Bob Mueller has been dealing with are obviously much greater. But there is this similarity. I did not recommend, I felt that was the legislative function. And I think in that sense, he has taken a similar position.
Right. Some people are interpreting part of his press conference as he's all but saying it's up to Congress now to impeach, but he doesn't go over that line. And then I stopped listening to CNN and MSNBC because...
Well, we're lawyers,
Yeah.
and that's both a plus and a minus. But we tend to focus, as lawyers do, on what are the facts, what is the law. The law of impeachment is not so clear.
Right.
And whoever the decision maker is, first the Judiciary Committee, then the House, then the Senate, they're on their own. And the job of the lawyers is to give them the equipment to make an intelligent decision.
Now, we have limited time. We could have many shows, and I'd love to have you back. And we can talk about that later. But let's talk about it, like the why, the process. What did the process of the impeachment? What were the fruits of that? We'll go.
I think a lot can be said about what led up to the impeachment in terms of what happened afterwards.
Well, Brock was not convicted on any of
He's not convicted on any of the charges.
because they determined George Mitchell, the former U.S. Senator, came in. Who was he the counsel for, or was he just
For the
Senator
Senate.
Mitchell was hired as counsel to the Senate, along with Bob Bauer, who became counsel to President Obama, along with Harold Pacious. They had 3 very capable lawyers. And Senator Mitchell met with counsel, and we talked about, among other things, what the vote should be, because the Constitution does not tell you, is it a majority, or
Right.
is it a supermajority, meaning 2/3, which it is in the federal Constitution. And Senator Mitchell expressed his views on that, and ultimately the Senate said, no, it's going to be 2/3 to convict. And as I wrote in my Concord Monitor piece, we knew before that trial began, because we could count, and many of the senators had made their views known. They weren't constrained the way a judge would be. So
Yeah.
they were publicly on one side, many of them said nothing, but we knew that more than 7 members of the Senate were not going to vote to convict.
right? But the process went on, and when I'm listening to this, it's almost like you are defining the court, its relations within itself almost, and regulating the judges and the judges' behavior, but then between the legislature and the courts.
And there's some very important developments that happened. Now, after the conclusion of the impeachment, after Brock was acquitted, he came before the Judicial Conduct Committee and was censured for his behavior. He came back then and sat as Chief Justice for another 3 years, I believe, plus or minus, and then John Broderick succeeded him as Chief Justice. Now, the consequences for the relationship between the legislature and the judiciary were pretty significant. First, there was a question about who has authority in terms of defining how the courts are going to administer their day-to-day affairs. Traditionally, the legislature had their fingers in that. Now,
Right.
how a courtroom is run, you'd think to yourself, so of course, all the lawyers, you would say, hey, that's the judge. And so what happened in this advisory case that John Cerullo mentioned about evidentiary matters, is that the Supreme Court, or the justices, advised there that this is a separation of powers issues. The legislature should have no fingerprints on how we run our day-to-day business. That caused the legislators distress.
Yeah.
And there was substantial pushback at several times over the course.
2010, there was a
And
pushback
so,
with the-
absolutely,
that
that's
populist
absolutely so.
legislature.
And it turns out now that in a decision by the New Hampshire Supreme Court, they said, well, it's appropriate for the legislature to have a role in the courtroom making process, subject to the extent to which there may be unconstitutional procedures. So the court is going to say, we're going to have the last word on whether your role, what you propose to do, is constitutional or not. So that's a nice and decent balance. Now-
separation of
Yes,
powers.
yes.
So this helped define
Yes.
the separation of powers and the balancing.
That's
of
right.
powers.
Now, there are issues that come to our mind as we think about the Fairbanks situation, where his problems with stealing millions of dollars as a probate lawyer from his clients, as well as his illicit activities on the district court bench. How are we going to deal with judicial conduct? And there has been an evolution of the nature of the entity that's responsible for overseeing judicial conduct. Now there are explicit ethical rules that are mandatory for judges. They must comply with the standards for judicial ethics, and then this judicial conduct organization will act and will have members including representation from the legislature and public members, and it's no longer just something that operates under the authority of the Supreme Court of New Hampshire. A substantial shift. Whether or not everyone's happy with it, it seems to me to be a clear consequence of everything that was happening that led up to the impeachment.
That's fascinating. Since when I got here, I was working with I was down at the National Whistleblower Center, and you come up here and you find out we rank in like the bottom 5 in terms of transparency.
Yes.
And state legislatures aren't held in. It seems to be practically any.
Well,
type of ethical
I think
behavior.
that's a discussion for another day.
That's a discussion for another day. Just an
David
irony.
raises an important issue. Every state has a judicial conduct commission.
Right.
Quite a while after the impeachment case, I chaired the commission in Massachusetts, and so I'm familiar with how those commissions operate. And in many states, in my opinion, the issues surrounding the New Hampshire Supreme Court, Chief Justice Brock, Justice Thayer, would have gone to the Judicial Conduct Commission. It is something perhaps not unique to New Hampshire, but a facet of New Hampshire culture. And that's what you write about in your book and you've been discussing here, that led this down a different path.
Yes.
If the same facts had arisen in state X, New York State, for example, chances are it would have gone straight to the Commission on Judicial Conduct, not to this. In a way, it was like a boil that had to be lanced.
Yeah.
Yes. Yes.
And others can speak to the aftermath, but there were lots of issues for one thing, between Chief Justice Brock and the legislature, which provides the funding for the courts. They didn't get along very well.
Never thought of that issue.
Well, that
'Cause
case
yeah.
about the phone call to the judge, one of the parties in that case, Senator DuPont, chaired the legislative committee in charge of funding the courts. Now, I'm not
Wow.
saying
Right.
Chief Justice Brock was never found to have committed an impropriety, but the fact that DuPont had to do with funding
Right.
and the case and this phone call, it made for an interesting question, and it became one of the
A dilemma,
And-
quite a
and-
dilemma.
And I think it's important that what Joe talks about there is that whatever was actually happening between Justice Brock and Judge Gray, the appearance of impropriety and the fact that some
Seizures.
judges who were recused from sitting on cases might read some of the materials and comment it, that creates the appearance of impropriety. And there's an interesting thing about the rules of ethics for judges. Nationally, until very recently, those ethics really didn't contemplate what an appellate judge may be engaged in. Communication by a judge with just one side of the litigation was focused primarily and almost solely, both in terms of the explicit ethics rules and how they were applied, was focused almost solely on the trial judge. There's now an amendment to that catches the situation that Justice Thayer was involved in, that catches the situation of a recused judge. Now, it's interesting, Joe is talking about the judicial conduct organizations. I should point out to you, John, coming from California, that it was in 1960 that California created the first judicial conduct organization. And so that's a relatively new development, long after impeachment, and now it's in every state has a judicial conduct organization, and New Hampshire's, in part as a consequence of the dissatisfaction expressed in the impeachment proceedings, is part of that.
You know, the whole home gas issue, the phone call that Chief Justice Brock was alleged to have made to the trial judge in this home gas case involving these two different home fuel companies.
Which the legislator was involved
The
in?
legislator
Yes.
was one of the parties to the litigation.
That's
And
what
it-
made it interesting.
Yeah.
Yeah.
And that's what created the appearance of impropriety.
And that appearance of impropriety also reflects the fact, the call itself reflects the fact, which we've been talking about, of sort of the professionalization and modernization and increased or fortified autonomy of the judicial branch. In 1966 was a constitutional amendment that constitutionalizes
Right.
the Supreme and Superior Court. In 1978, we get another constitutional amendment that makes the Chief Justice of the New Hampshire State Court the administrative head of the entire judiciary.
Right.
Now, in the old days, various courts had been, this is prior to what these guys would call court unification. Courts had been sort of nestled in counties. They had been financed by counties. They had been part of county administration or town administration, smaller, more local levels of government. What happens with court unification is that the entire system is now unified into one. It is taken out of the control of those, or taken out of the context of local
the
municipal affairs.
Power is brought to
Power
the
is
top.
taken away and brought to the top, and concentrated administrative control is concentrated in the hands of the Chief Justice.
And it's
Now, the Chief Justice's view, or rather, the Chief Justice's defender's view,
Right.
was A, he didn't make the call, he always denied having made it. B, if he had made the call, it would have been within his proper range of responsibilities as the guy who was responsible for the correct administrative functioning of the court. The claim was that a complaint had been brought to him, granted by a legislator, but by a citizen and constituent, regarding the sort of dispatch of that local court, what's going on, why has there been no news, and that it is sort of his administrative responsibility to kind of see to that.
I think it's important from the perspective of courts generally. This was a delay in the trial judge's ruling on a motion before him, which is an appropriate thing for the administrative head of the system to keep an eye on. Now, whether it was whether the appearance of impropriety was created because it may have been Chief Justice Brock who called the judge rather than the state court administrator or someone else, is what helps to cause part of our problems.
Well,
Now,
John,
another
We only
thing,
have a few minutes left because
Okay.
we could go on forever. We got about two or 3 minutes. Remember, Caesar's wife is supposed to be above suspicion. But while you're talking about this, I realize this was a process that had to be gone through. That's my opinion.
well, it's our
It
opinion,
really
too.
had to be gone through because that was a unique situation and about the power. I'm going to give Mr. Tobin. Do you have anything? I'd love to get you back.
One of the things I think to keep
We got
in,
3 minutes,
keep in
so-
mind about the professionalization of the courts is that there was a reason for unifying the courts, and that was that as law practice changed and evolved, people were finding that things were run very differently from county to county.
Yes.
Right.
So that while that may have made sense in a decentralized society, it did not make sense in a state where one hoped that a bedrock ideal would be the system would work the same, following the same rules across the state. And
Right.
so it was not irrational. In fact, it was modernization and ultimately improvement to have a unified court system with uniform rules. And I think that part of what happened here was the court as an institution was trying to become more professionalized for good reasons, and there was also the philosophical notion about the independence of the judiciary. But unfortunately, the court, because of Fairbanks, because of the recusal, it appeared to many people, who did not have a particular axe to grind, that this independent judiciary was not accountable and it wasn't transparent, and that bad things happened, inappropriate bad things happened in this independent institution.
exactly.
So from a sociological or anthropological point of view, it looked like the court system is very hierarchical, very secretive, wielding power and not providing information, and so those things overrode in people's minds any ideals about independence.
Right. Well, we only have 1 more minute, so I guess I'm going to have to wrap up. It was great to have you. I told you it'd go by fast, didn't it?
Did.
You thought you were going to run out of something to talk about for 10 minutes. I love this stuff, and one of the things from my research is this wasn't just a local thing. This was followed nationally, and it's part of an evolutionary process.
Because it was so rare to
Yeah.
impeach not only a judge, but the
We got
Chief
30
Justice of the
seconds.
State Supreme Court. Can you tell us how rare it was?
Well, I think we should. We'll get back to some of this, either singly or all together. But we're not going to be here next week, so we'll have the rerun of this. But thank you so much, and we'll see you in 2 weeks.
Thank you, John.
thank you.
Thank you.
Thanks, John.
Thank you.